Hi, my name's Desmond Manderson and I'm the course convener for Law in the Humanities, which is taught in the College of Law at the Australian National University. At Australian National University, we've just done a big refit of a lot of our spaces to modernise our community spaces and student spaces, and we've also got this great new big teaching building called the Murray-Ray Teaching Centre, and there's also a lot of spaces for students to work in around here, a lot of light, a lot of wood, and the spaces themselves have been designed to encourage innovative teaching. So we're teaching Law in the Humanities in this space over here, and as you can see, it's a very modern space. There are a lot of video setups and so on, and it's a very big space which allows us to break the room up in different ways. We can have small workshops or student discussions by spreading out the tables. We can do lecturing or videos by moving the tables over there, and it allows us to do some more creative things with our teaching. So here in this side, you see we've got this set up as a kind of interview setting, and what we're going to do is present an edited version of the famous Hart-Fuller debates on the meaning of law from the 1950s, and restage that debate as a real conversation between H.L.A. Hart and Lon Fuller. And that will be followed by student questions to the two actors, including myself, playing the parts of these characters. So the script comes exactly from the pages of the Harvard Law Review, but we have cut it down and interspersed their comments in a dramatic way in order to help people understand what was at stake at those debates and what they actually said about each other's positions. Now, why the Hart-Fuller debate in a Law and Humanities course? Because I think that the debate between a positivist theory of language and, let us put it, say, a purposive theory of language is at the heart of how we understand the relationship between law and the humanities. Law and the Humanities seeks inspiration and insight from disciplines like philosophy and history, but also from literature and film and art as ways of really advancing our understanding of legal issues, legal themes, and questions of justice in the law. Now, from a positivist theory or a theory of legal science, such as that advocated by H.L.A. Hart, those connections are irrelevant to law as law. They may be interesting thought pieces, but they can't affect how we understand law itself, because law is a linguistic or semantic exercise that is hermetically sealed from the influence of other disciplines. Politics might observe or comment on the law, so might philosophy, so might even literature, but they're not relevant to law as law. Whereas for someone like Fuller, those distinctions are not able to be held up, are not tenable in our understanding of law, and that law, in the words we use and how we understand it, is necessarily connected to these other ways of speaking about the world, these other ways of speaking about justice. And the kind of sealing off of law from the humanities is, for someone like Lon Fuller, both impossible and folly. So the stakes are very high in the debate between Hart and Fuller, and they are a very early kind of conversation which in some ways led to the whole Law and Humanities movement, which is what this course is also about.
Good evening and welcome to the show. Today we're privileged to have in the studio with us two of the greatest legal philosophers of the 20th century to recreate the famous debate that took place in the thrilling page-turner, the 1958 edition of the Harvard Law Review.
Thank you. It's a pleasure to be here.
Herbert Lionel Adolphus, H.L.A, if I may. Hart. After distinguished service in World War II, as when you worked at Bletchley Park on the Enigma project alongside some of the greatest minds in Britain, including Alan Turing, you took up a fellowship at New College, Oxford, where you came under the influence of ordinary language philosophers such as Gilbert Ryle and J.L. Austin. You took up the professorship of jurisprudence in 1952. How has ordinary language philosophy, with its emphasis on conceptual clarity, influenced your work as a legal philosopher?
My approach to the law is founded on the need to distinguish firmly and with the maximum of clarity law as it is from law as it ought to be. The existence of law is one thing, its merit or demerit another. Whether it be or be not is one inquiry, whether it be or be not conformable to an assumed standard is a different inquiry. A law which actually exists is law, though we may happen to dislike it.
Professor Longfellow, you are a renowned researcher and teacher at Harvard University, hardly less an established institution than Oxford. Your claim to fame in legal philosophy is as a critic of legal positivism. Why? Surely positivism is just common sense.
Professor Hart's essay seemed to me to suffer from a deep internal contradiction. At times he seemed to be saying that the distinction between law and morality expresses a reality which, whether we like it or not, we must accept if we are to avoid talking nonsense. At other times he seemed to be warning us that the reality of the distinction itself is in danger, and that if we do not mend our ways of thinking and talking, we may lose a precious moral ideal, that of fidelity to law. It is not clear, in other words, whether in Professor Hart's own thinking the distinction between law and morality simply is, or is something that ought to be.
Let's view this disagreement in the first place through the lens of legal interpretation. Professor Hart, you argue that legal interpretation is fundamentally objective and does not require, except in certain circumstances, any judgment or ethical position on the part of the judge. In other words, it is for the most part a purely technical and semantic exercise.
A legal rule forbids you to take a vehicle into the public park. Plainly, this forbids an automobile. But what about bicycles, roller skates, toy automobiles? What about airplanes? If we are to communicate with each other at all, then the general words we use, like vehicle in the case I consider, must have some standard instance, like automobile, in which no doubts are felt about its application. There must be a core of settled meaning, but there will be, as well, a penumbra of debatable cases, in which words are neither obviously applicable nor obviously ruled out.
But what would Professor Hart say if some local patriots wanted to mount on a pedestal in the park a truck used in World War II, while other citizens, regarding the Pros Memorial as an eyesore, support their stand by the no vehicle rule? Does this truck, in perfect working order, fall within the core or the penumbra? And how can you decide? In his treatment of the problem of interpretation, uncodified notions of what ought to be are viewed as affecting only the penumbra of law, leaving its hardcore untouched.
To insist on the utilitarian distinction is to emphasize that the hard core of settled meaning is law in some centrally important sense, and that even if there are borderlines, there must first be lines.
But what then is contributed to the process of interpretation by the common practice of supposing various borderline situations? Professor Hart seems to say, why, nothing at all, unless we happen to be working on problems of the penumbra. If this is what he means, I find his view a puzzling one. When we look beyond individual words to the statute as a whole, it becomes apparent how the putting of hypothetical cases assists the problem of interpretation generally. By pulling our minds in one direction and then in another, these cases help us understand the fabric of thought before us. This fabric is something we seek to discern as we try to make the statute a coherent, workable whole.
Professor Fuller, what you seem to be saying is that we cannot know the core meaning of a word or law without perhaps having undertaken some perhaps preliminary reflection on the purpose and aim of the law. So for you, this process of reasoning is not marginal, it permeates the whole process of interpretation. Professor Hart?
Of course, it is good to be occupied with the penumbra, But to be occupied with the penumbra is one thing. To be preoccupied with it is another. It seems true to say that the criterion which makes a decision sound in such cases is some concept of what the law ought to be in the light of aims, purposes, and policies, though not necessarily in the light of anything that we would call moral principles. It is easy to slide from that into saying that it must be a moral judgment about what law ought to be.
Is it not clear that it is precisely positivism's insistence on a rigid separation of law as it is from law as it ought to be that renders the positivistic philosophy utterly incapable of aiding our judge? Is it not also clear that our judge can never reach a satisfactory resolution of his dilemma unless he views his duty of fidelity to law in a context which also embraces his responsibility for making law what it ought to be?
Not at all. The word ought merely reflects the presence of some standard of criticism. One of these standards is a moral standard, but not all standards are moral. We say to our neighbor, "You ought not to lie," and that may certainly be a moral judgment. But we should remember that the baffled poisoner may say, "I ought to have given her a second dose."
But law cannot be simply a fiat of power or a repetitive pattern discernible in the behaviour of some officials. The respect we owe to human laws is surely something different from the respect we owe to the law of gravitation. Law must be supported by moral standards.
To soften the distinction, to assert mysteriously that there is some fused identity between law as it is and as it ought to be, is to suggest that all legal questions are fundamentally like those of the penumbra. It is to assert that there is no central element of actual law to be seen in the core of central meaning which rules have, that there is nothing in the nature of a legal rule inconsistent with all questions being opened to reconsideration in the light of social policy.
I was simply trying to show the role that reflection plays in deciding what ought to be done. I was trying to make such simple points as that decisions about what ought to be done are improved by reflection, by an exchange of views with others sharing the same problems, by imagining various situations that might be presented. I was assuming that all of these innocent and familiar measures might serve to sharpen our perception of what we're trying to do, and that the product of the whole process might be not merely a more apt choice of means for the end sought, but a clarification of the end itself.
So this brings us to the second stage of this debate. Professor Hart, you think that our obedience to the law is clarified by the separation of law and morals. Professor Fuller, you think that our fidelity to the law, or our sense that we have to have an obligation to it, even when we don't entirely agree with it, requires something else. But both of you see that the question is tested not only in everyday acts of the interpretation of laws and rules. Sometimes the moral legitimacy of the entire legal system can be called into question. Is the moral and legal status of a regime entirely separate problems, or are they necessarily connected? What does it mean to speak of our fidelity to the law?
Austin, an early legal positivist, was emphatic in condemning those who said that if human laws conflicted with the fundamental principles of morality, then there cease to be laws, as talking stark nonsense. On the other hand, if laws reached a certain degree of iniquity, then there would be a plain moral obligation to resist them and to withhold obedience. This simple presentation of the human dilemma which may arise has much to be said for it.
If this is the positivist position, then I have no hesitation in rejecting it. The dilemma, Professor Hart states, as the verbal formulation of a problem, but the problem, he states, makes no sense. It's like saying I have to choose between giving food to a starving man or being mimsy with the borogoves. On the one hand, according to Professor Hart, we have an amoral dictum called law, which has the peculiar quality of creating a moral duty to obey it. On the other hand, we have a moral duty to do what we think is right and decent. When we are confronted by a statute we believe to be thoroughly evil, argues Professor Hart, we have to choose between these two duties. I do not think it is unfair to the positivistic philosophy to say that it never gives any coherent meaning to the moral obligation of fidelity to law. If laws, even bad laws, have a claim to our respect, our fidelity, then law must represent something deserving loyalty.
After the Second World War, a prominent German legal positivist, Gustav Radbruch, considered the ease with which the Nazi regime had exploited our subservience to mere law, or expressed, as he thought, in the positivist slogan, "The law is the law, Gesetz als Gesetz," and the failure of the German legal profession to protest against its enormities. In a dramatic about-turn, he argued that the fundamental principles of humanitarian morality were part of the very concept of recht, or legality, and that no positive enactment of a statute that conflicts with these fundamental principles, however clearly it was expressed or however clearly it conformed with the norm-formal criteria of the validity of law, could be valid.
It is true that law cannot be built on law. Law has to be built on moral foundations. The existence of a legal system, even a bad or evil legal system, is always a matter of degree. When we recognise this simple fact, it becomes impossible to dismiss the problems presented by, for example, the Nazi regime with some simple assertion like, under the Nazis there was law, even if it was bad law.
Let us take an example. During the war, a woman who had apparently turned to other men denounced her husband under a Nazi-era criminal statute. The husband was arrested and sentenced to death. Pursuant to these statutes, although he was not executed, he was sent to the front. In the post-war period, the prosecution of the wife was successful. She was found guilty of procuring the deprivation of her husband's liberty by denouncing him to the German courts. Since, to quote the word of the courts, the statute was contrary to the sound conscience and sense of justice of all decent human beings.
The unqualified satisfaction with this result seems to me to be hysteria. Many of us might applaud the objective, that of punishing a woman for an outrageously immoral act. But this was secured only by declaring a statute established since 1934, not to have the force of law.
But Professor Hart seems to assume that the only difference between Nazi law and, say, English law is that the Nazis used their laws to achieve ends that are odious to an Englishman. This assumption is, I think, seriously mistaken. To me, there is nothing shocking in saying that a dictatorship which clothes itself with a tinsel of legal form can so depart from the morality of order, from the inner morality of law itself, that it ceases to be properly described as a legal system. When a system calling itself law is predicated upon a general disregard by judges of the very terms of the laws that they purport to enforce, when this system habitually cures its own legal irregularities, even the grossest, by retroactive statutes, when it has resort to forays of terror in the streets, which no one dares challenge, in order to escape even those scant restraints imposed by the pretense of legality. When all those things have become true of a dictatorship, it is not hard for me, at least, to deny it the honour of the name of law.
A legal system may be hideously oppressive and might deny to a vast rightless slave population the minimum benefits of protection from violence and theft. The stink of such societies is, after all, still in our nostrils, and to argue that there have or had no legal system would only involve the repetition of the argument.
Well, there we have it. Professor Hart seems to assume that evil aims have as much coherence and inner logic as good ones. I, for one, cannot accept that assumption. I also believe that when humans are compelled to explain and justify their decisions, the effects will generally be to pull those decisions towards goodness, by whatever standards of ultimate goodness there are. Accepting those beliefs, I find a considerable incongruity in any conception that envisages a possible future in which the common law could work itself pure from case to case towards a more perfect realisation of inequity. Even in the most perverted regimes, there is a certain hesitancy in writing cruelties, intolerance, and inhumanity into the law. And is it not clear that this hesitancy derives not from a separation of law and morals, as Professor Hart argues, but precisely from the opposite?
There are laws which may have any degree of iniquity or stupidity and still be laws. And conversely, there are rules that have every moral qualification to be laws and yet are not laws.
What disturbs me about the school of legal positivism is that it not only refuses to deal with problems of the sort that I have just discussed, but bans them on principle from the province of legal philosophy. In its concern to assign the right labels on the things we do, this school seems to lose all interest in asking whether we are doing the right things.
There is an extraordinary naivety in this view. Surely the truly liberal answer to any sinister use of the slogan, "Law is law," or of the distinction between law and morals is, very well, but that does not conclude the question. Law is not morality, do not let it supplant morality.
Hysteria, naivety. Let us put aside at least the blunter tools of invective and address ourselves as calmly as we can to the question. Did legal positivism, as practiced and preached in Germany, have any causal connection with Hitler's ascent to power? It should be recalled that in the 75 years before the Nazi regime, the positivistic philosophy had achieved in Germany a standing such as it enjoyed in no other country. German legal positivism not only banned from legal science any consideration of the moral ends of laws, but it was also indifferent to what I have called the inner morality of law itself. The German lawyer was therefore peculiarly prepared to accept as law anything that called itself by that name and was printed at the government's expense. Hitler did not come to power by a violent revolution. He was chancellor before he was leader. The exploitation of legal forms started cautiously and became bolder as power was consolidated by the Nazis. The first attack on the established order were on ramparts which, if they were manned by anyone, were manned by lawyers and judges. These ramparts fell without a struggle.
Well, gentlemen, we have here two fundamentally different visions of law and its practice. Yet both of you are committed to the value of law in our society. For you, Professor Hart, separation and clarity are its indispensable virtues.
If I am sometimes clearly wrong, at least I am wrong clearly. This surely is a sovereign virtue in jurisprudence.
And for you, Professor Fuller, it is law's turn to social values and its capacity for reflection and development that matter. The clarity of law, it would seem, might be more of a vice than a virtue, in your opinion.
What I have said may be clearly wrong. If so, it would be not for me to say whether I am also wrong clearly. I will, however, venture to assert that if I am wrong significantly.
If we speak plainly, we say that laws may be law, but too evil to be obeyed. This is a moral condemnation which everyone can understand, and it makes an immediate and obvious claim to moral attention. If, on the other hand, we formulate our objection as an assertion that those evil things are not really law, here is an assertion which many people do not believe. And if they are disposed to consider it at all, it would seem to raise a whole host of philosophical issues before it can be accepted.
I look forward to the day when legal philosophy can address itself earnestly to issues of this sort and not simply exploit them to score points in favour of a position already taken. Professor Hart's discussion seems to me to open the way for such a conversation, for it eliminates from this positivistic philosophy a pretense that has hitherto obscured every issue touched by it. I mean, of course, the pretense of the ethical neutrality of positivism.
At this point, let me open the floor to questions.
Professor Fuller, do you not think that your conception of law lends moral legitimacy to unjust law?
Exactly right. Of course does.
No, what it does is it demands of every participant in the system that they think of the project of law as ongoing rather than as already given. And that actually is also, I believe, a kind of moral vigilance that asks of people, particularly of people who are committed to the legal system, people like judges and lawyers who are inside a system, have a moral obligation to be pursuing the justice of the law as their project of interpretation. Now that is not necessarily perfect. That doesn't mean that we solve all the problems of the law. It doesn't mean there is no space left for law reform projects from other kinds of sources. But it means that we don't give up on the process of understanding and interpreting in relation to purposes of a law and thinking through those purposes with more depth and reflection than Professor Hart is prepared to muster. We are always, I think, there are always situations when we are standing outside the building, protesting against the law there and seeking the kind of law reform advocacy that Professor Hart has spoken quite eloquently about just then. But we are also always in this position of trying to persuade a judge, a bureaucrat, an administrator to listen to your argument and not to close it off and say, well, gazettes als gazettes, I've got no choice. Judges have choices. Words are porous. Interpretations are ongoing. We make those arguments to judges and to lawyers constantly in our lives. And we don't just accept that the judge's hands are tied. We ask them to think further, to think deeper about what they're doing. I don't think that's a kind of... It's framing the moral legitimacy of the law as a goal. But I think once you get past the idea that it's either yes or no, which is Professor Hart's sole question, is to say yes or no, once you understand with me that the project of law is always a matter of degree, that we are always failing, but we are always striving, then I think the moral legitimacy is a way of pushing the law to continue its development rather than really treating it as a static entity.
Now, the problem of Professor Fuller's theory could be seen in his use of the phrase, the justice of the law, as if there is always justice in the law and we just have to find the justice of the law.
No, it's a project.
That could be the injustice of the law.
Sure, but we don't define law in terms of its injustice. It works towards justice. That does not mean that it's just.
A law need not work towards justice. It depends on the legal system you have.
Well, that's exactly
Some
our
legal
disagreement.
system,
whether you think that the word law can be eviscerated of moral content like that.
On the question, a more specific question about the justice of the law, sure, there are some just legal systems and there are some unjust legal systems. The confusion arises is that If I think there's always going to be justice in the law, I go around looking for justice in the law. I live under an illusion that the law will promote justice. But sometimes the law promotes injustice.
No, you see, we both agree on that and disagree, because I think you're right. I agree with you when you say, in fact, I would go further. I say there is no such thing as a just legal system. Justice is never achieved, but it is always a project. We realise the injustice in law in order to keep working our interpretations and our values to improve the legal system from the inside as well as from the outside. It is not my claim that some legal systems are just. On the contrary, it is my claim that all legal systems are a work in progress, and it's precisely to preserve the nature of a work in progress that I am making these arguments about the fidelity of law and about the nature of legal interpretation.
So I suppose we could refine and fine-tune our disagreement to the following. I don't even agree with the proposition that all legal systems are a work in progress towards justice. Some legal systems are working towards justice. Some legal systems are working towards injustice. Not all legal systems are working towards justice. Some are. Even it could be, and that is a contingent matter, it depends. Sometimes a majority of legal systems in the world are working towards justice, sometimes not. And there is no reason why legal systems must necessarily work towards justice. Legal system is just a mode of governance. There are many ways to govern, and you could use governance for good or for ill, and better be vigilant of the fact that it could be used for good or for ill than to assume that it is always working for the good.
If I may ask a question to the both of you, we've talked a lot just now about the qualities of the law, the nature of the law, and whether it has inherently moral characteristics to it. But if I could just ask plainly, what is the law?
Can I just begin with providing an answer? And I think I have an answer to that question that Professor Fuller does not. And I'll be interested to hear what he has to say in response to such a basic and fundamental question. So my answer is simple. Law is a union of primary and secondary rules. Now, there are many rules in the world. There are social rules, rules of etiquette. There are also legal rules. We need to distinguish legal rules from these other kind of rules. A legal rule emanates from a system that consists of primary rules and secondary rules. So primary rules are rules that govern conduct directly. Secondary rules are rules about rules. And it is the existence of secondary rules, particularly the rule of recognition, that creates a legal system. The rule of recognition tells us what primary rules are valid and what rules are invalid. And law just is the union of these two kinds of rules. And I would be interested in what Professor Fuller has to say about the definition of law, because I'm pretty sure he does not have one.
No, I mean, I think that the problem with Professor Hart's description there is that the word rules becomes a kind of a black box that we just assume, we don't know much about law, but we know what we like. It just happens to be this thing that we can identify. The problem is that as soon as you say the word rules, you either ignore the question of interpretation, or you assume that it can be worked out by what? By recording to other rules? Is it turtles all the way down? One rule interpreted by another rule, interpreted by another rule? No. At some point, rules are the exact thing that must be given meaning. And we give meaning through processes of interpretation that are not simply reducible to codes or can be nailed down in that way. It's not the fact about rules that I object to. It's the fact that rules seems to assume that, well, let's put it this way. There is an assumption that rules are a kind of self-basting pudding, that we just put them on the stovetop and then they cook themselves, but they don't cook themselves. That's a process, that's an effort, and it's a social effort. So my answer to Professor Hart's neat little description here is that he completely begs the whole question, which is how do we determine the exact content, not the words, but the meaning of the words. And that meaning is a social and cultural process. Why do we have law? Not because we need order, but because it's a project worth having.
I hope you notice how slippery Professor Fuller is. He has evaded your question. Your question is, what is law? And you asked for a definition of law. He provided none. He provided none because he's incapable of giving you a definition of such a basic concept that we are discussing, and he went on this huge digression without answering the question at all.
Professor Hart, I'm curious to know how we conclude that a certain alleged meaning is in the core of a word or in its penumbra. Do we not apply certain values, as Professor Fuller might put them, in deciding whether the meaning is in the core or in the penumbra of the term, or the application of the term?
Excellent. So any competent user of a language should be able to tell you that. What does it mean to be able to speak English? Part of it is to understand what the English language words mean. Right? So let's imagine that you're trying to learn a language. You're trying to learn English. You have to learn the grammar and sentence construction, but a large part of language acquisition is learning the meaning of words. And you become a competent user of the language if you have mastered a critical mass of words and you know how to use them. And people can understand you when you use those words. So therefore, when we know what is core and what is penumbra, that too is a sociological fact, is a linguistic fact. It's a fact about how people learn words and use words, right? And insofar as law requires language, and law will always require some form of communicative tool, and the way we communicate is through language, there will always be the core penumbra structure of law, because words come with a core and penumbra, right? That is true just by watching and observing how people talk and how people use language. So in that sense, it is unmysterious, right? And we don't want. The whole purpose of my philosophy is not to mystify something that is quite straightforward.
It seems to me that the fundamental disagreement that we have, at least on this point, is that, according to Professor Hart, words have a core of meaning that we know before we give them any context at all. This meaning exists abstractly or absolutely outside of any context, and therefore that we don't have to inquire about what the law, for example, is on about, or what the context is. The word is already clear. And that the penumbra are situations in which that alreadiness does not exist. But to me, that completely misunderstands the way in which any word works, and that we are already making those judgments in order to work out whether something is a core or a penumbral meaning. It's precisely Professor Hart insistence that there will be many cases in which judges do not have to think about context, do not have to think about values, can just apply the law without thinking. That seems to me both inaccurate as a theory of language and dangerous as a theory of justice.
Ironically, perhaps, we need both of your perspectives to fulfill our obligations. Sometimes we need to turn to the resources of Professor Hart in order to argue against the vagaries and excesses of government power. Other times, we need Professor Fuller if we are to persuade judges and lawyers to heed the voice of conscience and demands of justice. If law is to be like a vehicle in the park, we sometimes need Hart to put a brake on it, and other times Fuller to give it some momentum, lest it ossify into some statue. Thank you both, and good night.